everyone. Good evening. This is the first event of term for both the Jurisprudence discussion group and the Obligations discussion group. This evening we have the book launch for Torts and Other Wrongs by John Gardner, a collection of essays that John wrote on private law, both previously published and two new ones, I think, Sandy, that were previously unpublished. Of course, tragically, John passed away in July of last year. It's a testament, I think, to John's strength and his commitment to work and to philosophy that he finished this book whilst gravely ill. It's a small but important consolation that we get tonight to engage with his ideas, still both old and new. And to help us do that tonight, we have Herstein from King's College London and the Hebrew University of Jerusalem, Sandy Still from Modern College Oxford, and McBride from the University of Cambridge. And I think we're going to spend about 10 or 15 minutes with each commentator, and then open it up to audience Q&A. I think we're starting with Nick.
Oh, no, Sandy.
Oh, Sandy. Okay.
All right, thanks, Josh, and thanks very much to the organisers for the ODG and the JDG for putting this together. I'm sure John would have been delighted that so many people have come to the launch. So as Josh said, this book reflects the culmination of 15 or 20 years of thinking on tort law and private law more generally. So there are nine previously published essays in the volume. There's a volume going around, by the way, if you want to look at it. And there should also be some flyers, which will give you a 30% discount on the book if you want to use them. And there are two new pieces in the volume, one of which was only completed in June last year, which I think Nick is going to touch on in his comments. So the title of the book, Torts and Other Wrongs, in some ways understates its ambitions. Many of the essays in the book address theoretical issues that arise across private law and raise really deep moral philosophical problems. So in the book you'll find discussions of the nature and respective roles of corrective and distributive justice, the justification of compensatory duties, the role of good consequences in justifying legal duties in private law, the justification of strict liability, and the moral demands of the rule of law in private law. So I think anyone who's interested in the theoretical foundations or any normative issues about private law would gain enormously from reading this book. So what I'm going to do is to try and give a sense of a few, and really only of a few of some of the themes of the book across the essays. Okay, so I'm going to pick on two, and I should have. So these are just two small themes of a very rich book. So first of all, I think a lot of John's work in tort theory is characterised by a scepticism about grand oppositions between law and economics and corrective justice on the other hand. And so I think although there was much he disagreed with in law and economics and much he disagreed with in corrective justice, he wanted to reduce the problems to their proper size and to try and eradicate what he saw as false debates, where there was more agreement than seemed present at first. So, for example, John's reluctant to think of there being as much of a divide as is usually thought between instrumentalist theories of private law and corrective justice theories, or instrumentalist theories of tort law and corrective justice theories of tort law. So the reparative legal duties imposed by tort law, he thought, are partly justified by moral duties of corrective justice. And furthermore, tort law helps to partly constitute those moral duties and make them more determinate. So far, so corrective justice-y. But he also thought that tort law has to be assessed by its contribution to the doing of corrective justice in the world. So its efficiency, if you like, is relevant to its justification. So the extent to which tort law contributes to the actual doing of corrective justice in the world is relevant to its justification. So if tort law leads to less corrective justice in the world than would exist if tort law didn't exist, that's a major strike against tort law. So to the extent that tort law is inefficient, if you like, in achieving conformity to moral duties of corrective justice, that counts against it. So in his own words, he says, we need to ask, does this norm of corrective justice advance the cause of conformity with the moral norm of corrective justice? If not, then one cannot make a good case for the legal norm by relying on the moral norm. Giving the correct answer corrective justice to the question, what is tort law for, therefore does not exempt one from showing that the law is instrumentally sound. The answer corrective justice tells us what it is that the law supports. The law of torts is supposed to be efficient at. It is supposed to be efficient at securing that people conform to a certain, partly legally constituted, moral norm of corrective justice. So that's still miles away from law and economics as it might ordinarily be characterised. So it's nothing to do with wealth maximisation, it's nothing to do with maximising satisfaction. It's about maximising, or at least increasing the conformity to moral norms of corrective justice. And furthermore, the moral duties that justify the reparative dimension of tort law are non-consequentialist in character. The moral source of those duties isn't that the existence of those duties would lead to better consequences in the long run. But the consequences of legal institutions in serving conformity to those underlying non-instrumentally justified moral duties are relevant to the justification of the institutions of tort law. So I'm going to raise two minor quibbles about this. I don't think John would have been very happy if we were entirely without criticism of anything he said. I remember when I first came to Oxford, I had just published a book, and kindly Nick, John, and Rob Stevens and Sarah Green all agreed to comment on it. And what I was expecting were just paeans of excellence to the book, but that wasn't what happened. John very gently raised a few deep problems, and less gently Rob Stevens raised a few, and Nick too, for that matter. So here are the two quibbles. One is it's related to a point that Victor Tadros has made in another context, which is that when defendants are ordered to comply with their legal obligations, or when rather their stuff is taken from them in order to satisfy those legal obligations. So my property is seized in order to satisfy my duty of corrective justice. It's not obvious that that's conformity to the obligation of corrective justice. So it might be that we shouldn't just be focusing upon, or it's not just the conformity to the obligation which should be relevant. It's something like discharge of obligations of corrective justice is another consequence which is relevant to the justification of these institutions. So when your stuff is taken from you, your duty to compensate might be discharged, but it's not obvious that you're conforming to the duty. The basis of the duty no longer exists. A second quibble is I wonder whether John sometimes sailed too close to the wind in relation to economistic theories of tort law. So as I said, he had no truck with economistic theory of value, but on page 129 of the book, he writes that an economistic defence of the moral norm of corrective justice and its counterpart legal norm of corrective justice is in principle possible. And he concludes that chapter by saying that the only real way to attack economistic theories of tort law is to attack their theory of value. So I'm not sure what the force of the in principle there is. I mean, someone could try to do it. Someone might try to offer an economistic defence of the moral norm of corrective justice, but I just think it would always fail. So I think that's too generous. I don't think there is a good economic defence of the moral duty of corrective justice, because any such defence would end up painting the duty of corrective justice as extremely contingent in character, depending upon the good consequences in the particular case at hand. And in chapter 2, I think he seems to accept actually that the economistic explanation of the moral norm would probably be unsuccessful. So he might actually have conceded that. A second major idea for which John is particularly well known and which is developed in detail in chapter 2 of the book is the continuity theory of reparative moral duties. So this theory is offered as an explanation of why we have moral duties of corrective justice. Duties, say, to undo the losses which part constitute or result from our wrongs. So John's view essentially is that even if my duty, say, not to damage your car through my careless act has been breached, because I say I destroy your car, the reasons why I had that duty persist and demand conformity. So suppose that the reasons for the duty not to interfere with your car deleteriously are to do with your well-being. To the extent I can still serve your well-being in some way and still respond to those reasons by paying you compensation, I have to do that now. So although the specific duty not to injure your car is destroyed by the breach, nonetheless the reasons for that duty continuing to demand conformity and imperfect conformity might amount to compensation. And because perfect conformity to those reasons will not be available, John described imperfect conformity as doing the next best thing. So your duty is to do the next best thing to not breaching your primary duty, and that's just a way of a label of describing what it means, the sense in which it's imperfect conformity. So let me describe one bad and one good objection to this view. The bad objection, I think, is that often wrongdoing causes such appalling harms that compensation could never serve as the next best thing. So if you wrongfully disfigure me, how can giving me money be the next best thing to never having disfigured me? The money will never come close to making it up. And yet, the objection goes, courts will award damages in these sorts of circumstances. So I think that's a bad objection for a number of reasons. An obvious reason is that the continuity theory isn't intended as an explanation of all of the awards of damages that we find in legal practice. But another reason is that even if you've wrongfully caused another to suffer extreme harm, if there's something you can do just to mitigate it even a little bit, you still have a duty, or will often have a duty to do so. So even though you can't protect them from all of the effects of the harm you've caused, if there's something you can do which will undo the effects of the breach, and that thing partly explained why it was wrongful for you to do that thing in the first place, then often you're going to have a duty to do it. So I think the continuity theory can explain why we sometimes have a duty to compensate in cases in which intuitively it's not plausible to say that the compensation amounts to the next best thing, but it's doing some good for the victim. So one good objection, or at least a better one, is that the continuity theory generates duties to compensate in situations in which there are no such duties. So consider John's analysis of the famous case of Vincent and Lake Erie. So here the captain of a ship damaged the plaintiff's dock during a storm in order to protect the cargo on board and the people on board from harm. So it looks like the defendant's act was morally justified in order to save the lives of the people on board. But the court in that case nonetheless imposed the duty to compensate for the damage to the dock. And intuitively many people think that's right. And John explains it by virtue of the continuity theory. So the reasons for the duty not to damage the dock persist after its breach, and they now require compensation. So although it was justified not to act on those reasons at the time of the emergency, the reasons nonetheless persist, and now it's possible to do something to conform to them and pay compensation. So the trouble with this argument, I think, is that the same argument can be made in a slightly different Vincent-type scenario with much less intuitive results. So suppose that I come on the scene of Vincent and Lake Erie, and I damage the dock in order to save the crew, and suppose that that was necessary in the circumstances in order to do so. Am I really under a duty to compensate for the damage that I've done? On the continuity theory as explained by John, it seems that I might be. The reasons why I had the duty would continue after the damage, and if those reasons constituted a duty in Vincent, why not in my modified Vincent case? So one response might be to say that in my modified Vincent case, I don't benefit from damaging the dock, whereas the captain does in Vincent. But even if that helps, that response doesn't seem to be open to John, because he thought that the duty in Vincent arose quite independently of any benefit made by the captain. So I think this is a remaining puzzle for defenders of the continuity theory, how to avoid proliferating duties to compensate in certain cases of justified harms. So before I finish, I just wanted to say three things on a personal note really about the book. The first one is, when I read the book, I'm just struck by the enormous influence of John's work on my own work, and many of the questions that I'm interested in are really I'm interested in just because, or to a large extent because of John, and that my work is so much less rubbish because of John and talking to John about these things. The second thing is, just how enormously lucky I was to get to know John a bit and to discuss these questions with him. And reading the book just makes you think how much I will miss him in the future. And finally, I'm also just extremely glad that we have this book, because, and indeed John's other work, because I think so many people are going to get a lot of joy from engaging with philosophical virtuosity and flair and good sense, which are his hallmarks. Thanks.
Okay, so I'd also like to thank the organisers of this book launch, but also I'd like to thank Sandy, not only for inviting me to come along and talk on this occasion, but also for doing such an excellent job of making sure that the book finally represents John's intentions as to what it should look like, and making sure that happened. So I've chosen to talk about the chapters that bookend John's book. The first chapter on torts and other wrongs, and the final 11th and not previously published chapter on breach of contract as a special case of tort. And so these chapters are concerned with the other wrongs part of the title of John's book. The first chapter deals with the difference between torts and equitable wrongs, and the final chapter deals with the difference between torts and breaches of contract. And in both chapters, John's starting point is an argument that the law of torts is a law of A, civil recourse, B, for wrongs, C, to which primarily corrective justice is attempted, that primarily the law is trying to undo or correct something. D, it's doing so in a primarily reparative mode. Its primary goal is to undo what's happened by repairing the losses suffered by the victim of the tort. E, in response to claims for unliquidated sums, so actions for debt aren't part of the law of torts. And F, where the duties breached are non-contractual. So John locates the difference between torts and equitable wrongs in element D. What distinguishes a tort from an equitable wrong is that when it comes to an equitable wrong, repair is not the law's first choice as to how to respond to that wrong. The primary response to an equitable wrong is to make the wrongdoer disgorge the gains he's made from his wrong. And the reason for this is that the main reason why equitable duties exist is to secure that the defendant's dealings are conducted for the plaintiff's advantage and not for the defendant's own. Whereas the main reason why the defendant has duties to a plaintiff in the law of torts is to protect the plaintiff from losses. In the final chapter, John obviously locates the difference between torts and breaches of contract in element F, while spending some time rejecting competing views that some other element can account for the difference between torts and breaches of contract. But what then is the difference between a contractual and a non-contractual duty? John's answer is that a contractual duty is voluntarily assumed while a non-contractual duty is not. An obvious objection to this view is that duties of care arising under Headley-Byrne are non-contractual, but also voluntarily assumed. And John forestalls this objection by arguing that when it comes to voluntarily assumed duties, the fact that one undertook the duty is an affirmative reason for finding that you have that duty. In contrast, he argues the role of a voluntary assumption of responsibility under Headley-Byrne is to remove an objection to finding that the defendant owed a duty of care, rather than supplying us with an affirmative reason for finding that a duty of care was owed. Like Sandy, I think John would have been disappointed if I simply agreed with him on these points, so as not to let him down. Here are a couple of counter-arguments against his positions for us to consider. First, in distinguishing between torts and equitable wrongs on the basis that the law responds to a tort in a primarily reparative mode, while that's not the case with an equitable wrong, a lot of work has to be done by the word primarily. As cases like A and B and Redler show, reparation is a well-established part of the armory of responses to an equitable wrong. And the idea that reparation is the primary remedy for a tort, because torts consist in the breach of a duty not to cause another loss, is difficult to maintain when we look at torts like the economic torts, which often work to protect someone from being prevented from making future economic gains, or the trespass torts, which seem indifferent to whether the claimant suffered any loss at all as a result of the defendant's actions. And even John concedes in the book that the idea of loss needs, he says, careful unpacking. I think that with more time, John might have been interested in exploring the idea that there's no need to draw a distinction between torts and equitable wrongs because there's no such thing as an equitable wrong. John does acknowledge that some forms of trustee liability are not based on the trustees having breached a duty, and it would be interesting to explore whether all forms of equitable liability can be so explained. So, for example, Boardman and Phipps is routinely explained in the books as an example of someone being made to give up a gain that they've obtained as a result of a breach of fiduciary duty. But my own preferred explanation is that the only duty that fiduciary is subject to is a duty to act in the interests of their principal, and the law attempts to help them perform that duty by making it clear to them that they're disabled from making a gain, from doing anything that might possibly result in their breaching that duty. So when the fiduciary is made to give up a gain, it's not because they've done anything wrong, but because the law simply gives effect to the disability under which the fiduciary always labours. And if the fiduciary does fail to act in the interest of their principal, they are not held liable for breaching that duty, but they're held liable because the law assumes they have performed their duty and the law requires them to make the facts on the ground conform to that assumption. Second, the distinction between assumptions of responsibility that ground a duty and assumptions of responsibility that remove an objection to finding that duty is quite familiar in tort law. For example, in Canton Griffiths, Lord Wolfe argued that the fact that the ambulance service in that case had assumed a responsibility to pick the claimant up removed an objection to finding that the ambulance service owed a duty of care to the claimant, which is that the courts had no business telling the ambulance service what its priorities should be. However, it seems clear that Hedley-Burns style assumption of responsibility plays a more positive role in finding that duty of care was owed to the claimant. In John's language, the assumption of responsibility gives the court an affirmative reason for finding that such a duty of care was owed, contrary to what John thought. I think a more promising ground for distinguishing between the duties, breach of which amount to a tort, and other duties, including contractual duties, is to draw a distinction between duties that help support or constitute an institution and duties that do not. So we could call the first type of duty an institutional duty and the second type non-institutional. The duties breach of which amount to a tort are non-institutional in nature. By contrast, breach of an institutional duty tends not to be called a tort. Contractual duties are institutional in nature, in my view, as they help to support and constitute the workings of the market. But so are the duties surrounding the institutions of bailment or innkeeping or holding property on trust for another. All such duties being institutional in nature are hived off from the non-institutional duties that form the basis of the law of tort, and breach of these various duties are variously categorized as breaches of contract, or breaches of an equitable duty, or simply and hopelessly sui generis. On the last page of the last chapter, John does briefly consider the possibility that the law of contract is the rule book or one rule book of the marketplace. But for him, contract comes before market. Contractual duties are as non-institutional as tort duties, because like tort duties, they're duties that exist first as moral duties and are, and I quote here, legally recognized, i.e. according to the law they would exist apart from the law, and the law only tries to give legal effect to them. But taking on that view is a much larger task than we can attempt here tonight. And so the conversation goes on, and it will go on for a very long time, and at a far higher level of sophistication and understanding than would have been possible had John not made the last-minute decision all those years ago to switch from studying modern languages at Oxford to studying law. We are all in John's debt, and it's debt that's only become much larger thanks to the publication of this brilliant volume, which is currently obscured. This brilliant volume by a very brilliant man.
Thank you very much. Thanks for the invitation. It means a lot to be part of something like this to me, given that I held John in great personal and professional esteem. When I asked Sandy what I should talk about, he suggested chapter 5, and when I reread it, hadn't read it for 10 years, I thought it was an excellent choice, given that it is the earliest essay in the book. So we had the very last, and I'll talk about the first. It was also nice to just read something by John in his mid-30s. I just found that kind of interesting. It's from 2001. What is in the book is a slightly revised version of that essay. The essay was published in a collection honoring Tony Honore, and it has a lot to do with Honore's ideas. And again, I thought it was a good choice for this occasion. There's something fitting to John, I think, to honor him by talking about an essay that he wrote to honor someone he held dear. I think that's somehow appropriate. The essay in many ways is typical, I find typical to John's work. It is very, very rich in ideas. I like to think about John's essays, or those that I read, as more English gardens than French gardens. There's always this richness, this baroqueness about them. You get so much out of reading his work. It's not just about sustained argument, although there's always one, right? There's always a point to the essay, but there's always so much else going on. There's culture and all these observations about life and relationships. And I always feel I learn and I grow from reading his work. It is never narrow, it's always broad. Another feature of John's work, which again comes out in this essay, is he has a way of making law and analytic jurisprudence and writing about tort law in ways that connect it to the human condition and big questions that pertain to us all. He makes law interesting and not dry. And again, I learned so much from him in that regard. In this particular essay, you see this when he discusses Honore's idea of outcome responsibility. So very briefly, the puzzle is how is it there is outcome responsibility? Outcome responsibility, John explains, means that there are obligations and liabilities for the outcomes that we cause, even if it wasn't our fault, we couldn't have done otherwise, and so on, and that seems problematic. Right? It seems like liability and obligation without moral responsibility. And how do we justify this phenomenon in the law? And what Honore gestures towards is to say that outcome responsibility, these kinds of obligations and liabilities, are very significant for our very identity and agency as moral agents. And John takes that, I wouldn't say embryonic, but brief discussion, or not fully developed discussion of Honore, and really fleshes it out in this essay. He takes the opportunity of taking the discussion further, and really it touches on very deep and interesting questions. The essay is 42 pages long, and I have 12 minutes left, so I cannot go into it any further. But I do, of course, recommend reading it. Another thing that was nice to see here is that this very same topic comes up later in his recent book, From Personal Life to Private Law. He discusses again these questions of responsibility or liability for the outcomes of our actions and how that connects to our life, to our story, how we are what we do, and things of that nature. So it's nice to see the progression of his thinking over the years by going back to this earlier piece. Another feature that I think again comes out in this essay, and I often find in John's work, is that it is instructive. I always feel, and this essay was published just as he took over as professor of jurisprudence here, and I always felt that he was kind of tending to the profession. He was kind of concerned with the state of jurisprudence. And in his writings, I always felt that he was also doing that. It was an argument, but he was also teaching, at least I always felt that I was learning how to do jurisprudence. The methodology was always very transparent, as he's sort of telling how we should go about doing this kind of work. And along the way, there are always clarifications of confusions, and he draws all these distinctions. Again, I saw this in this essay as well. Again, it was, as I said, I find it very enriching. One way to describe what's going on in this essay is that it is about a distinction that Gardner, I think, was drawn to, and in some respects, I think even coined the terms, the distinction between trying and succeeding, which pops up at various junctions in the essay. The idea of, for example, liability and duty for failing to succeed is what's kind of going on in the background in the discussion I referred to before about Honore. Another distinction, another place where this distinction comes up is this sort of kind of little discussion that pops up at some point between reasons to try and reasons to succeed, or he puts it in terms of reasons to fi and reasons to try and fi. And he says, well, look, I have this distinction between trying and succeeding, and that can illuminate this specific area of practical reasoning. He says, people tend to confuse or conflate reasons to succeed with reasons to try. So if I have a reason to fi, to succeed in doing something, it seems that kind of ipso facto I have a reason to try, right? Because if I have a reason to fi, I thereby have a reason to try and fi, given that the best means of fiing is trying to fi. But then he says, wait, don't make this confusion, and kind of spends a bit of time elaborating a little bit, making these very interesting observations, which illuminate kind of practical everyday cases. So he says, for example, if there's someone on the other side of the world which needs our help now, we have a reason to help. But it's a practical matter, alas, there's nothing we can do. And therefore, we don't have a reason to try, because trying is not really a means for achieving that end. The reason to do something, or to succeed in something, kind of falls apart from the reason to try and do it, given that here, trying is futile. Sometimes we'll have a reason to fi and a reason to try to fi, but they have nothing to do with each other, he says. You may have a reason to succeed in something, but given that trying would be futile, you may still have a reason to try, but not because it's a reason to succeed in something, but for other values altogether. So think about going down with the ship, fighting the good fight. That has to do more with values like nobility, or dignity, or integrity, or fidelity, or solidarity. I'm just trying. I know I'll fail, but that's not the point. And he has a few more of these, which is very interesting. The first third of the book, and where he does most of the work, kind of drawing out the distinction between, and there he talks about duties to try and duties to succeed, is in the first couple of sections, 3 sections, where he talks about basically the nature, logic, the structure of obligations in tort law, primarily or only strict liability and negligence. And he asks about their logic. And what basically he wants to say is strict liability, they're about duties to succeed, while negligence, as far as the duty of care goes, is about a duty to try. So that's John's view. Now, a duty to try is, according to John, a duty to act with a certain view, a certain intention. I act with the view of showing care, taking care of others, of their interests. And that's what the duty of care and negligence, according to John, is about. It is a duty to try to act with care. Then there are duties to succeed, and duties to succeed don't really care about whether or not one tries or intends. They're just about the bottom line. You need to succeed. If you succeeded, great, you lived up to the duty. If you didn't, you didn't. It doesn't really matter if you intended, tried, could have done otherwise, and so on. And according to John, strict liability torts have that logic. So he takes this distinction between succeeding and trying, and comes up with this distinction between 2 types of duties, and then says, look, this is how tort law, the law of accidents, perhaps more accurately, is structured. But then, of course, there are other views out there which John has to contend with. So one view, and the view that he begins the essay with, is to say that, well, the law of accidents is all about trying. It's never about duties to succeed. Negligence is about the duty to succeed, and strict liability is about, the duty to try, and strict liability is also about the duty to try. Now here the challenge is to think about strict liability in terms of a duty to try, which seems unintuitive. Right? But that's the position John, at the beginning of the paper, tries to knock down. The criticism is that given that strict liabilities require us to succeed, that entails that they're effectively requiring of us to do the best we can, right? Utmost care, complete care, total kind of erasing of the self, of the interest of the agent in the service of others. And that seems too much. While negligence imposes a duty to try, which much more sensible, it is in other words reasonable. And this is considered an argument against strict liability torts. They impose a duty of care that is too demanding, okay, for various reasons. Now, John says, well, perhaps the duties to try which are so demanding are wrong or problematic, but the law is not structured that way, so it's incorrect to describe the law in that way. According to John, if you look at the law of strict liability torts, it doesn't care about the trying or the intending or anything of that nature. It just doesn't matter. Even if you try to the utmost of human ability and fail, you're still liable. And if you don't, you don't. And liability, under strict liability, doesn't seem to turn on these types of considerations. But that's not enough, says John. Maybe we can do a little better by furthering the argument of the opposition here. Maybe there is what he calls a derivative duty to try. And so strict liability law, when you look at it, is about the success. It's about the bottom line, not about the trying. But, as he says, to will the end surely is to will the means. And therefore, given that the means of success is caring, being careful, trying, there is a derivative obligation under strict liability law to do anything and everything that you can to avoid harming others. And then we fall into the problem. But John points out, and again, there are these several little observations which are extremely illuminating. And he says, well, more care is not always the means to achieve the end of avoiding harming other people. That is just not true. I came up here from London on the train, and I somehow spent a day, I think, without harming the 7 billion people who live on the earth, or how many there are today. And even if I had a strict liability obligation not to harm them, I did not harm them. And I guarantee that I didn't really try not to harm 7 billion people, I just didn't do it. Why? Because that's how the world is structured. I can't really harm everybody. And I don't really need to take care, it's just how it is. So often John talks about luck that helps us avoid harming others rather than care. And then he says, sometimes more care, trying more, doesn't always really yield more safety for other people. Sometimes there's a ceiling, right? So beyond this point doesn't really matter. You do more, it's not going to make a difference. Sometimes doing more is actually more risky from a certain threshold. So he gives the example of the overly cautious driver who's trying so hard to be careful that he's actually a menace to everyone around him. And then he says, interestingly, strict liability obligations would actually involve an obligation to show less care from a certain point rather than more. Sometimes he said, no care is the best way to go in order to act as safely as possible. Right? Just get on with it, just do it. If you start thinking and reflecting and trying to be careful, probably you'll be more of a risk to others than simply forging on. So his conclusion is, no, the duty of care, strict liability towards not involve a derivative duty to try, thereby a duty to succeed. Then he has the opposite view to contend with. The opposite view is that obligations of accident law are about duties to succeed. Here the battleground is negligence and the duty of care. So the argument here is negligence is also about a duty to succeed, not, as John believes, a duty to try. And there are several, there are at least a couple of arguments for this position. We don't have time to go really too much in depth to talk about them. But mainly the argument, or the best argument, is to say, look, when we assess someone's conduct and whether or not they lived up to the reasonably prudent person standard, we don't look to intentions, we don't look to trying. That's not the point. We look to the conduct itself in some sense. And the way to articulate this is to focus on risk, which John didn't seem to like. To say, well, what we care about is risking reasonably. And if you you risk other people unreasonably, that's a violation of your duty of care, and if you didn't, then you lived up to your duty. And we don't look to intentions or trying or anything of that nature. But John says, no, the duty of care is a duty of care. Care means care, to paraphrase. And by that he means it is not a duty to show reasonable risk. It is a duty to actually care, which involves these morally saturated ideas, like intending and trying and so on. Now this part of the essay is sketchy. So this is an invitation for people to think more and develop this idea more. John primarily argues from an example here, and he says, look, the caring is kind of inseparable to an extent from the acting in a way that's safe or it's not risky. The two go together. And he seems to think that we can't really think about him in a distinct manner. So here's the challenge to John's view. The challenge is as follows. Are there cases in which a person, in terms of the risk, in terms of the duty to succeed, they act in a way that's safe? They generate reasonable risk to others. However, they do not try to do so. Or either they even intend to risk other people in an unreasonable manner. And as a consequence of that conduct, someone is harmed. Are they liable or not under the law? If the answer is yes, they are liable, John is right. Because then, even though the conduct itself was safe in terms of risk, the failure to try means they failed to live up to their duty of care, and because the conduct caused injury, they are liable under negligence. However, if the law says, no, they're not liable, that would entail that the law really only cares about the succeeding. It doesn't really care about the caring. An example that I tried to come up with, I drive my car and I intend maliciously to drive really, really fast in order to risk the children in the school next to the road. I put the car in a higher gear. I step on the pedal. Car is making a lot of noise. I'm convinced that I'm driving really, really fast and I'm putting everyone at risk. I'm not trying to care. However, it turns out that the car is faulty. The higher gear is really a lower gear. All the noise is because the car is in lower gear, but I'm actually driving under the speed limit. So in terms of the risking, I'm in the clear. In terms of the trying, I'm certainly not in the clear. Someone jumps in front of the car, I hit them, they're injured. No one could have stopped. I'm not negligent because I failed to stop. The question is, am I liable or not under this case? I think not, as a matter of the law, but I'm not sure. Anyway, so here I disagree with John, but I do think this is one of those instances in which someone could come in and do for John what he did for Honoré, more fully develop